to establish, so the court would grant a remedy. The paradigm requires that each of the parties take on certain onuses. So in Delgamuth, the court affirmed that to prove title, you have to show that Indigenous people were here, your society, your nation was here first. That is, when the settlers came, your Indigenous nation was there, occupying your territory. That you occupied your territory exclusively, in the sense that you, it was your nation and not another that had the right to the land. Although the court has said that there could be a concept of shared exclusive, where perhaps if neighbors by their own laws agreed to function together on the territory or use the territory in certain ways together, that's definitely okay. But you have to show your relationship, First Nations relationship to the land in 1846 as being an exclusive right of occupancy, and that there's some continuity between the relationship of the land and the people who are alive today. Whether that's being held alive in stories, in place names, in governance, and perhaps the land passes at the feast, even though others are occupying it. There's some continuity that needs to be shown, and that's the proof of title.
Can you tell me anything about the Doctrine of Parliamentary Supremacy?
Right, that's a good question. That's a back pocket trick of the Doctrine of Discovery. The Parliamentary Supremacy assumes that the legal order that's brought in by the Crown Government is supreme. And so the Doctrine of Parliamentary Supremacy says that the government that the Crown installs, if through legislation they pass a law, that law overpowers the common law. That law is supreme. So that's what the Doctrine of Parliamentary Supremacy is. We have, since 1982, kind of overtaken the Doctrine of Parliamentary Supremacy by constraining Parliament through the Constitution. So the Doctrine of Parliamentary Supremacy has kind of taken a bit of a backseat to the Constitution, because the Constitution is now held up as the supreme law, and if the government passes a law which is, say, contrary to fundamental rights or freedoms, then that law can be struck down, whereas before the Constitution was supreme, that law would overpower the common law. And the reason it's a particularly devious little trick in the context of Aboriginal and Crown relations is because the courts accepted that, for example, the Royal Proclamation, they said in the early cases, that is reflected common law. So if for example, through the Fishing Act, the Parliament passed a Fishing Act which allocated and managed all the fishery, that act, not the proclamation, and the common law that it was said to embody, you'd look to the statute and not to the common law. And it also was a particularly nasty trick with treaties, because here these treaties were concluded which were intended to be nation-to-nation relations going on, forming into time. But the court, instead of looking at the treaty, would look at, for example, the Migratory Birds Act, which abrogated the treaty right, and through the Doctrine would stand up and say, well, too bad about the treaty. So we've seen it as kind of a pernicious little doctrine, but nevertheless, it was based on the supremacy of the Crown Government's parliaments. I thought of the supremacy of the Crown Government's thought.
You were talking about the Royal Proclamation, and I was just wondering, with the BC Treaty Process, do they honor the Royal Proclamation, and what are your thoughts?
Well, the BCTC process is not based on the Royal Proclamation. In fact, the BCTC process has quite categorically, the government's negotiation mandates quite categorically say that it's not about giving effect to the law. It's about, compromise and agreement people want to reach. And in fact, the BCTC process is hard driven the federal government's comprehensive claims policy, 1973, which was essentially based on the extinguishment, treaties being an extinguishment of any rights and title, which the Crown didn't recognize, but nevertheless they recognized it for the purposes of extinguishing it. And the BCTC process, the government negotiation mandates that are brought to the table, are premised, although the words are said in different ways, on the de facto extinguishment of Aboriginal title as being the condition upon which the governments will move into treaties. So you get, certain lands allocated and certain, protections and resources and whatever under the treaty package. And then there's this clause that basically says that whatever Aboriginal title else there is in the territory, that's no longer going to be exercised. And the federal comprehensive claims policy has actually been internationally repudiated a number of times by international bodies specifically. And when challenged, the government doesn't say, oh, well, we're following the jurisprudence even of our courts. They just say, well, everyone's free to make a deal, and this is the way that we'll bring our mandates to the table. And that's why you've got a lot of First Nations in British Columbia who are involved in the BCTC process, and you've also got a lot of those who are involved, tirelessly trying to work to change government negotiation mandates.
You mentioned the Enbridge Pipeline. How, and in general, what sort of factors do you consider to be legal as far as the compensation for companies going in and extracting resources from their land? Do you think it should be based on risk? And if so, do they get compensation if something does go wrong and the environment is damaged? Or should it be based on loss of use of land or functionality, or what type of compensation do they deserve, even not just for the services that they provide, but the fact that it's on native land?
That's a good question. Well, I think that you'll hear a lot. I'm just going to circle around that question. I promised to get to it. But I just wanted to circle around because you hear a lot of talk about reconciliation. The courts have said that Section 35 is intended to reconcile the pre-existing Aboriginal occupation with the assertion of Crown sovereignty. And so you hear a lot of talk about reconciliation. And on the government side of the ledger, the talk that you get about reconciliation is that it's all about compromise. We've all got to give and take, and we're going to arrive at something that will work for everybody. But if you could just take that ledger and look at Indigenous laws of respect, and I don't think that, I'm overstating this, you can't compromise a law. Like if the law is that you have to respect all living things in the environment and find a balance in a way that we can all live together, it's not a compromise. That piece isn't to be compromised. But if through the free, prior, and informed consent of Indigenous people, there is a way for this project to proceed, then we can talk about compromises. Then we can talk about who gets what, who benefits, and how decisions will be made and how things will be shared. So I think that if you're going to give effect to legal laws and orders, the international standard of free, prior, and informed consent is a very good place to get the discussion onto the question that you asked, which is, okay, so let's say we're at the first stage and we're looking at the risks and benefits. The risks that First Nations will look at under their legal regime and laws, and the risks that Crown governments will look at, where they're driven by the economic engine, are going to look a little different. And if out of that analysis, Indigenous people say this risk is not worth this benefit, I don't care what the benefit is, we're not risking our fishery, our culture, we're not risking our language, we're not risking whatever it is that we're not risking this ecosystem, whatever it is that they say, this risk is not worth this benefit, that's where free, prior, and informed consent steps to the plate and should govern. So then the question is, how can true legal orders with very different risk assessments, find a path forward? And the answer is in a respect of both legal orders, and not have one dominate the other, but with good dispute resolution mechanisms so that these legal orders can function together in a good way. And by the way, it may be that certain decisions are no. Like, that's something that we don't accept in the paradigm of the legal orders that we are living in, but some legal orders might say, this is just a no. It's not a matter of, risks and benefit and who's going to compensate and how's that going to be done. Our legal order says no to this, and that's got to be, one of the big pieces of the discussion, is to decide whether or not the project is a go, and if so, what do you do with the no? And that's something which is at the beginning of the question. At the end of the question, if the project does proceed, and many over the objections of the Indigenous nations, and there is a lot of impact or loss, and maybe not much benefit, then we are in also a paradigm where our legal system hasn't really worked out how are those damages going to get calculated. Like, you've got every fortnight the last speaker of an Indigenous language is leaving the earth. That's taking all of that wisdom and all of that knowledge into the spirit realm, and we've lost that cultural blueprint on the earth forever. How do you compensate for that? Where an oil spill, for example, might depress the community to such an extent that we no longer have speakers that are able to practice the fishing culture and therefore pass on all that fishing knowledge, and eventually the language goes. We don't really have a compensation fund that's in place for this. So I think that your question is a challenging one, because I have the law on either side and say we already know what the answers are. What we do see from Enbridge and from the submissions before the JRP and from what the court has decided is that there isn't any real, people are only talking about, the risk being worth the benefit, but no one is talking about what happens if the worst happens. Nobody is talking about how is it that that's going to get spilled out on the ground in terms of a restitutional factor, and I don't know the answer yet either. It's going to be a battleground.
But they also have to incorporate probabilities into that, because, if this Enbridge Pipeline brings them economic opportunities and brings economic resources into the communities and in the country as a whole, that has to be balanced with the slight chance that something bad may happen, because the pipeline or the oil tankers haven't spilled yet. You can't just assume that they will.
Well, you see, so the more we get into this discussion, the more we're into the political realm. But if we back out of it for a moment, because we're not going to agree, and there'll be a lot of opinions in this room, and everybody will have their own. I think that the realm that I'm trying to clarify is the constitutional and legal realm, where before you get into a risk-benefit analysis based on the economy of it all, and the probabilities of it all, and crystal balling it all, who are the players who ought to be making decisions based on the values embedded in their own legal systems. And I'm at this stage really trying to draw a bright line on the fact that Indigenous laws and legal orders have a very different set of values which will bear on those questions, and the result will be different when those values are respected. So I don't want to cut you off, but I also don't want to dive too far into the political debate in the public domain about whether this is a good thing or a bad thing. I'm really trying to clarify a better relationship amongst the legal orders that are affected by a decision such as this.
Yeah, that really helps.